YouTube, yeah. Admit. It. You.
Have you been watching still?
I haven't heard from them. Oh, it's me. Yeah, I need to find it. There it is. All right. All right. This is 003-2464-2019 L&L Huggins Real Estate Investments Inc. versus Society Hill Spirits LLC and Craig Crossley. I think we're here on plaintiff's motion to compel for sanctions for post-judgment discovery. Is that right?
Yes, Your Honor.
Okay. And you're, Mr. Crossley, you're muted right now.
My apologies.
That's right. The record should reflect that the plaintiff is here represented by counsel, and Mr. Crossley is here also representing himself. I've read the motion. It looks like we ordered that responses to discovery be made back in what, May or something. And
Yes, Your Honor.
I'm assuming you haven't received responses.
We have not, Your Honor.
Okay.
Right.
Mr. Crossley,
I'm sorry.
are you going to be able to get responses to the discovery?
Yes, we are. You know, obviously we've been hit with COVID. We had 5 family deaths and 3 hospitalizations close to a month long in the family that we've been trying to deal with. Just getting past all of that, but then trying to compile all of the information with all of our partners and them having to go back to their own legal and accounting firms to provide us all of the information that opposing counsel is requesting. I mean, obviously, as I said, we've got about 60 pages of interrogatories that they want responded to, and I completely understand that, and we want to resolve the issue. But when I'm dealing in the midst of COVID with trying to get everybody together and get their information, especially with what I've been going through personally with my family, it's just been a bit difficult to get done. As I've said, we want to make every attempt to try to make this right. You know, we've told Mr. Huggins that as well. You know, again, it's also a little bit difficult that he is walking around publicly describing this as a personal vendetta against us. Again, you know, he's asked us to speak with him. We've tried to speak with him, but he starts shouting matches and arguments. We told him that we needed to go raise money with our investors to try to get his loan paid off. And instead, he compiled a personal dossier against all of our investors and went to our investors to convince them not to loan us any additional money so that we could pay him off. But he wants to have information on our houses to try to get those. So we're trying to do everything that we can. It just doesn't help when he's walking around interfering in our ability to conduct business or to even repay him the loan. We want to repay him, but you know, when he tells our investors, no, you should partner with me instead, and I'll go after not just my money, but your money, and we can profit off of it. that's interfering in a bad way. Like I said, we want to get it taken care of, but it's disingenuous for him to go around and keep us from doing so.
Well, you don't have to talk to him at all. He is a lawyer, and you should only talk to his lawyer anyway. But the deal right now is we don't care about whether you pay or not. They want their information to decide if they can collect or not. And now it's been, I don't know when this was ordered back in. It was May 30th was when you were ordered to. And so you've had 3 months, about 3 months to compile stuff.
3 months, but we've been down for about a month and a half to 2 months, right?
I understand. But have you given anything to the plaintiffs?
No, we've got it probably 60% done. We've got a large majority of it done. As I said, it's about 60 pages of information. And we've gone through and done quite a bit, but we're still waiting on other information to come in from our outside partners because they've requested all of their bank accounts and transactions for 5 years. They've requested, I mean, there's a lot of information that they're then asking my partners to contribute at the same time. And I'm fine with that. It's just that I don't have any ability other than pushing them. And that's my point. When they are then going to my partners and convincing them not to participate, it kind of defeats my effort. Then they want to tell me that I have to pay for their additional hours, but they're the ones that are producing undue burden on me to have to get this stuff done if they're meeting with my partners and convincing them not to provide the information or not to participate.
Well, you need to provide what you can provide.
Okay.
And make reasonable efforts to obtain everything they're asking for. And if you
I can do that.
it changes things a little bit, but right now you've provided nothing.
Okay.
And so they need the discovery responded to. If I gave you another 30 days, or
yes, sir.
Get it?
I can get it in, and what I can do is I can get it in within the 30 days, letting them know the information that I'm still waiting on response for. That way, if they want to follow up differently or whatever they can, but I can absolutely give the 60 or so % that's completed within the 30 days. That's not a problem.
Okay. I mean, you need to comply with all of it, but give what you have with any explanation you have for it. Because they need to get the discovery done so they can decide what they're going to do from here.
Understood.
But you don't have to talk to their client at all. In fact, you probably shouldn't talk to their client at all because their client has an attorney. So if you run into a situation, just say you can't talk to them because they have an attorney. Anything else that the plaintiff wants done at this time? This point?
I think this is a good plan. Maybe if the court is okay with it, we could maybe set some kind of status conference or reset this motion for 35 days from now, just in case. And I'll take it off the docket if it's unnecessary, but rather than having to file another motion.
Yeah, see where you are 35 days from now. We'll give you a date. I don't know what day that'd be. Probably somewhere around mid-October. Let's say October 20 something.
Okay.
How about October 22nd? 23rd? October 23rd.
Okay.
Let's have it set for see where we are on the 23rd. Just basically, I won't make a decision on the motion. That way you don't have to file a new motion. And between now and then, let's see how well you do in responding to the discovery. Anything you can't get a hold of, explain to them who you're trying to get it from and why you can't get it. It's probably the best way to do it rather than just ignoring them.
Got it.
And we'll revisit this on that day and kind of see where we are. So I'll hold off holding. I mean, because what happens if we don't get it responded to? They have the right to have you held in contempt of court, and you actually could be jailed for a civil contempt for failing to comply with the court order. So we don't want that. The jail doesn't want you, especially right now. So
right, absolutely. Okay.
And you're not going to get anything accomplished by that. So let's give you one more shot at it. I understand it's been a tough time, but we still got to get this moving and get it moving the right way.
Understood.
So will that work?
Absolutely, yes, sir.
Will that work for the plaintiff?
Yes, Your Honor. Thank you.
Okay, we'll just, basically, we'll reset this for that day and between now and then, do the best you can to respond, okay?
Yes, sir.
All right, we'll see
Thank you.
y'all then. Thank you.
Thank you.
Bye-bye.
Bye.